essentially held in custody for trial. Pragmatically, that trial probably would not occur for anywhere from 6 months to a year. So the result of finding somebody sexually dangerous at a probable cause hearing is to hold that person who's already finished their sentence for anywhere from 6 months to a year. So these were all the uncertainties that were before me in spring when I was presented with the Rodriguez case and then the Reese case. In the Rodriguez case, what happened is the defense counsel, Mr. Farrington, offered into evidence a series of articles by Dr. Hansen, who was recognized as the leading expert in the field. Dr. Hansen had done a study of studies, that is, he had studied all the various studies of what the rate is of sexual recidivism, the rate of reoffending by persons who had been released from custody. And as a result of doing a study of studies, he gathered up about 17,000 individuals, and he had done a very careful analysis of what the risk is of recidivism for these people, what characteristics make them more likely to offend, and a whole series of studies that he had done. Mr. Farrington, defense counsel, offered that. In the Rodriguez case, the government had no objection to their admission, and they were offered, and I read them as part of the evidence in the case, and they were, after all, the empirical evidence surrounding what is the level of dangerousness, what factors make somebody dangerous. So I read them in the Rodriguez hearing, and I was in the midst of writing my decision in Rodriguez when the Reese case comes. In the Reese case, at the hearing, it's a different defense counsel and a different prosecutor. And I read all this information about what the literature says about sexual dangerousness. I knew it. I could have, in theory, said nothing, and just as a judge is not supposed to do. If a judge is dealing with a mortgage foreclosure case and happens to have majored in economics and knows about the law of mortgages or has read studies about them, the judge is not expected to forget them or ignore them. I could have essentially used this as part of the background of that a judge does in terms of studying the literature about sexual dangerousness. I thought, it was found to be an error by the Supreme Judicial Court, I thought it was fairer rather than just say, essentially know it and not mention it, that I said to the prosecutor, listen, I've read all these articles. They speak about the issue of what the true dangerousness is of various offenders. You can't separate this issue from that. I asked the defense counsel if he wished to offer it. He said he did. In this case, the prosecutor objected. Previously, they had not. And I said, well, no earlier objection, but I will give you, how much time do you need to offer me any literature which you think I should read? And I gave her the time that she asked for, and indeed she submitted, I think, 3 articles, one of which was by the same Dr. Hansen, who was, and they were much along the same lines. So I came to the view that it was fairer, as opposed to knowing this and acting upon it, I thought it was fairer to have offered to tell the parties, listen, I just read it. I can't ignore it. I can't ignore what my knowledge is about the literature concerning sexual dangerousness, and I'll give you a chance to respond. That was found to be in error. It's not something routinely that I do, but the other thing you should understand is that the sexual dangerousness hearings are really a different animal from almost everything that we do in criminal, certainly in the criminal sphere. Because in the criminal sphere, the question is, did somebody in the past do something? And therefore, the evidence is focused on whether that person did that thing, and whether that person did that thing with the required criminal intent. In a sexual dangerousness hearing, the question is, will that person do something in the future? And therefore, there's a much broader range of evidence, because you need to know a lot about a person to be able to consider whether that person in the future is likely to be committing offenses. And I thought, and the fact that a whole lot of people have been studied to see which characteristics of people make them more likely to, was part of that. So I know it's a very long-winded answer to your question. The answer is, do I do it routinely? Absolutely not.
I do find that, troubling, as did the prosecutors that spoke to me, because, again, as a judge, as you indicated, in your canons and so forth, faithful to the law, I didn't see you as an assistor to the defense an assistant to the defense, but as someone who listens to what the defense brings to you, and then you have to make it based on not your knowledge, because we all bring knowledge of our experiences, and yours are certainly extensive, but is it not the duty of the judge to take the evidence at hand, not the information that you've garnered over the years of...
Well, yes and no. Certainly with regard to the particular case, you of course only take the evidence at hand. With regard to knowledge of the literature in a particular area, I don't think we're expected. I mean, if we have read a great deal on a particular subject, whether we have a case involving insanity and we happen to know a good deal about psychiatry, I don't think a judge is asked to know everything the judge knows. So I placed it in the category of background information about this issue of sexual dangerousness that I think would be appropriate for a judge to have used in making a decision, as opposed, certainly if there had been any information about this individual that, well, of course I would never have it, but then it would be...
I don't mean to interrupt you, but in the Reese case, for example,
right.
They had defense counsel, correct?
Right.
And did you not go and get that information and say, here, use this? I mean, maybe not physically, but it appears to be that is what is told to me that you did. You went and said, hold off, let me go get this information. You should really look at this because this is good stuff that'll help you. Maybe you didn't use those words, certainly, but is that
I think what I did is I said, I've already considered it. Would you wish to offer it into evidence so that we part of the record and gave the other party the opportunity to respond to that. Again, I thought it was appropriate. The SJC agreed with you. It did not. It is a very unusual circumstance. I did what I did because I thought it was a fairer thing to do as opposed to acting upon information that I may have. I thought it was fairer to tell the parties, listen, I've already read this, and to give the other side a chance to provide me with literature that would be different. As it turned out, the literature they gave actually was not really very different on the issue. I thought it was fair. The SJC agreed with you and thought that it was error. So I certainly abide by their view. But my view of it was not to help the defense. My view of it was to be fair to all sides and not to act upon information that the parties did not have a chance to themselves review, and to be fair, frankly, to the prosecutor to give her a chance to present articles that could be to the contrary.
But you wouldn't have to do that if the defense didn't have the articles because they did not.
Well,
I mean, just happened.
Yes, I mean, I guess that what I would say to that is I still need to determine whether or not it was likely. And so what you would be asking me to do is to evaluate the issue of whether it was likely without considering all the information that I learned about these 20,000 offenders in terms of what factors make them likely to reoffend. So, in theory, I could have essentially tried to divorce myself from all that I had learned about sexual dangerousness, which factors make somebody likely and which make them unlikely. But I think it's very hard for anyone to do. And again, I take the view that it was fairer to be upfront with them and say, I've read it, it's part of what I know now, and to give them a chance to respond. It was really not designed to help or hurt anybody. I thought I was being fair, frankly, to the prosecutor to be candid and say, I've already known this, I've already read this, I can't reasonably put it out of my mind, and give the prosecutor a chance to furnish me with different information. Again, I was found to be in error, so I certainly
the prosecutors were not happy about that, obviously.
Well, this prosecutor was not happy. Again, the previous prosecutor allowed that to come in without objection. So one prosecutor said no problem that they come in. This prosecutor, a few days later, thought differently. But yes, I'm sure this prosecutor was unhappy with me.
Now, continuing on with the sexually dangerous person, if you could for a second, Judge, let me just get my notes here. The language of that law and those guidelines did not originally include things like within 5 years, and I know that's come up and that's been documented in memorandums and information. What prompted you to decide